an agency of government, okay, that is not properly constituted cannot fight corruption. Cannot, because in UAC versus Mark Floyd, Lord Denning said, in law, if a matter is void, and law is a nullity, as you cannot put something on nothing and expect it to stand, it will collapse. So when you look at the establishment out of the EFCC, you look at their functions and objectives, it does not matter how long they have been in existence. Once they are not properly constituted, they are not properly constituted. And the principles of law are that where you have a defect, he who comes to equity must come with clean hands. You must be properly constituted before you can derive authority and power to make corrections in society. You understand? So they have laid down their case. Part of their prayers also is that when the federal government have deployed funds to the states by the derivation principle, the government have no right under any guise, EFCC, NFIU, or whatsoever, to teleguide those resources to determine how it is spent or used. Because upon the deployment of those funds to the state by constitutional compliance, the federal government divests itself of those funds. Part of their prayers is that the federal government have no such right under any guise to come teleguide those funds. Now, the Supreme Court is going to rule on it, okay? But the truth is that we must talk about...
Isn't that a gaffe in the law? Because, I mean, we are talking about accountability here. So how, if the federal government, in a way, cannot monitor how these funds are used?
If you talk about federalism...
So how does accountability, you know,
no, if you talk
play
about,
out here?
If you talk about federalism under a federal system of government, the autonomy of the states, okay, just that in the country, so many things are messed up in terms of operations and guidelines. Ordinarily, the states are supposed to be the ones, you know, taking care of their resources, getting it directly from source and contributing to the center. But in this case, we have a lopsided one where the federal government is the one in charge of everything and they deploy to the states. So when you deploy to the states, a federal state, a state that is autonomous and independent, their argument, whether right or wrong, is that the federal government divests itself of that fund and should not come under any guise to teleguide it. Let the Supreme Court rule on it and let's see what it is. But as to the issue of the constitution of the EFCC, if you look at it from all angles, the Constitution in Section 12 must be complied with. Because as we speak, it has not been complied with. And then the organization cannot continue to subsist in that error. So perhaps the EFCC should be reconstituted or go the way of the prayers of the 15th state that I described. In which case, every conviction it has secured from the day it started operation and every case it has undertaken and ongoing will be invalid.